since the time of conception of what eventually became the CAA 2019, the Citizenship Amendment Act of 2019 became clear, which was actually the 2014 Bharatiya Janata Party manifesto, 5.5 years before the enactment in Parliament, without discussion within 24 hours almost. Thereafter, the threats issued time and time again by the top echelons of this government about the chronology, that the CAA would be followed by the NRC and the NPR, or NPR and NRC, made the original intent even worse because it caused social turmoil, upheaval and insecurity. Now we have, on 11th March 2024, the final passage of the rules. No act actually becomes operative till the rules are passed. And very often the devil lies in the details, so to speak, and it is in the rules that the problems begin to surface. Let's just see what happened post March 11th. And I'd like to take you to an incident, tragic incident actually, in 24 South Parganas, reported by the Indian Express and the New Indian Express. On March 20th, the night of March 20th, a very young, a 31-year-old man, Devashish Sengupta, was found hanging in a room of his small home and causing obviously tragedy in the family and a lot of consternation in the village around. And I quote from the New Indian Express, his relatives have claimed after his death that he had been experimenting panic attacks ever since the announcement of the implementation of the CAA, because he was particularly worried about his father, who is bedridden and had migrated from Bangladesh but lacks proper documentation of migration. So the issue is not just religion, because he is a Devashish Sengupta. It's also a question of documentation. And that's where we shall explore further with this explainer. Now, when you want to talk about documentation and citizenship, a relationship which is untenable anywhere in a developed democracy, because if you look anywhere in the world, nowhere is a documentary test of citizenship permitted or conceived under the law. We can't do it without looking at the northeastern state of Assam. Now, we at CJP have been working on the ground in Assam since 2017, which is now a good 7 years. And our experience has been devastating. Our vibrant team there, multifaceted and diverse, has documented various aspects of the tragedy around the citizenship crisis. One such aspect is a list we have prepared, a list that is available on the CJP website, which actually lists down 99 citizenship crisis deaths. You can find it on our website, and it's important to just scroll down and look at those. Out of these 99 deaths, 29 were in detention camps, the dreaded detention camps of Assam. 41 of the 99 are Hindus. Please recall. One is a T-tribe person, one a Gorkha. 11 of the 29 who died in the detention camps are also Hindus. Point being that the intent behind the amendment of the Section 2 of the Citizenship Act, original 1955, to insert a marker of citizenship by excluding Muslims ostensibly from Afghanistan, Pakistan and Bangladesh, eventually when it plays out on the ground, will cause not just the tragedy of Devashish Sengupta, as we saw in 24 South Parganas, but will cause unimaginable and unprecedented social turmoil. Extremely impoverished sections of the population, marginalized, who live undocumented lives, who do not have access to their documents. And there's a large amount of us out there. It could be transgender, it could be Dalits, it could be minorities, it could be your farm laborers, it could be your Pravasi Kamgar, your migrant workers, it could be your fish workers, your agriculturalists, your farmers. It could be just about anybody. Because how do you produce those required 9 or 6 or 14 documents that are required to pass the citizenship test? Now let's come to the actual operationalizing of the amendment. What does it mean? How does it work? How is it likely to pan out? Now, the CAA amends Section 2 of the Citizenship Act of 1955. Illegal migrants were first defined in 2003, by the way, under the first NDA government. Through this 2019 amendment, the CAA 2019, Section 2(1)(b), only persons belonging to the Hindu, Sikh, Buddhist, Jain, Parsi or Christian communities from Afghanistan, Pakistan or Bangladesh and who have been exempted by the central government under the Passport Entry into India Act 1920 and the Foreigners Act 1946 shall not be treated as illegal immigrants. Consequently, such persons shall be eligible to apply for citizenship under the 1955 Act. This means, in simple language, that the process of applying for citizenship under naturalization or registration will be prioritized and accelerated for this particular section, and they can get it within 5 years. Originally, the process of naturalization required you to be a resident of India for 11 years before you could apply. The cutoff line here, arbitrarily again, is December 31st, 2014. Nobody really knows what is the logic really behind that particular cutoff. It's not as if we had the Indo-Pakistan War of 1971 and you had an influx at that time. There's no such rationale. But anyway, 31st December 2014 is the cutoff. What are these 5 or 6 documents that they have to produce under the rules? The rules, like I said, were finally brought in on March 11, 2024. You have to have a filled application form. You have to have one of the documents listed under Schedule 1A of the Act, which include but are not limited to land or tenancy records from the origin country, which is Bangladesh, Pakistan or Afghanistan, birth certificates from there, identity documents from there, land or tenancy records from there. Third, one of the documents from Schedule 1B, which is the ration card, Aadhaar card, license or any letter issued by this government or court to the application with an official stamp. That's number 3. This is a problem. An affidavit verifying the correctness of the statements made as attested by a notary, oath commissioner, magistrate. Also, a document providing evidence that an applicant or either of their parents was a citizen of independent India, passport or birth certificate to prove that, and if available, the copy of an expired foreign passport or residential permit. After all this is completed, the district level committee and then the empowered committee will authenticate all of this and you will get a digital certificate. There's an online portal now set up after the rules have come in, and the Hindu reported on Sunday there are lots of issues with the online portal, lack of clarity about how the documents are going to be submitted, what these documents mean. Curiously, this aspect of an affidavit notarized and authenticated by a local thing has raised eyebrows and generated a lot of comment. Who is the DLC and who is the empowered committee? The composition itself is being questioned because it includes IB officers and vaguely described nominees of the central government with their meager quorum of 2 individuals. So the process is often the punishment, as we've been seen under some sections of our law. And if you have bad implementation of a bad law and a perverted implementation of that law or a manipulated implementation of that law, it's likely to cause unspeakable tragedy and turmoil on the ground. Interestingly, within days of the passage of the 2019 amendment, we have counted 150 petitions were filed in the Supreme Court challenging this amendment. On December 18th, 2019, the Supreme Court issued notice on all these but has not heard the cases since, because primarily the Union of India said that since the rules have not been framed, there's no urgency to stay the case. Now, the moment the rules were framed on March 11, 2024, the first petitioner in the case, the Indian Union Muslim League, went back to the Supreme Court and asked for a stay. Now, this argument is carrying on, and sometime in April, we'll hear the case take place. What are the grounds for these challenges? The first major ground is that the amendment of 2019 does not pass the test of reasonableness. And what does this mean? Again, in a layperson's language, it means that in a diverse country like India, even though you have Article 14, Article 15, Article 19, Article 21, which gives you equality before the law, equality and the right to life, a life without discrimination, the government can, if the criteria is reasonable, put in certain reasonable restrictions. If you recall, in the famous celebrated case of Navtej Singh Johar in Union of India, for instance, it was this test that was applied. And the test that was applied was to differentiate between those included in and excluded from a group. Now, does the marker of religion, as this amendment brings in, pass this test? Manifestly not, because on various grounds again, and those need to be examined. if the intent of the act in a country like India, concerned about persecution of religious minorities, which is in itself is a laudable proposition, is concerned about the persecution suffered by persons who flow into India from Afghanistan, Pakistan, or Bangladesh, the question to be asked is religion the only marker of this persecution? And then if you look at the facts available from the ground, well documented from these three countries, several things come out. Number one, under the Pakistani constitution, for instance, under 263B of the Pakistani constitution, there is one section, the Ahmadiyas, who themselves consider themselves to be Muslims, but who Pakistan's law does not. And therefore, they are a persecuted minority. But this amendment does not really cater to them. So Ahmadiyas are excluded, and that means it does not pass the reasonable classification test. Similarly, in Afghanistan, you have Hazaras and Shias, who are well known to be persecuted, and they do not in any way enter into this definition of this exclusive category that has been given citizenship, accelerated citizenship. It's also not clear why other religious minorities like Tamil Hindus from Sri Lanka, Jews, Baha'is, and Rohingya Muslims from Myanmar have also been excluded. It creates two classes within these migrants who have come. Those of these refugees who came before 31st December 2014 are now, under the amendment, not illegal immigrants. But those who may come after that from the same categories will be now treated as illegal immigrants. Again, extremely arbitrary, doesn't make sense, and doesn't pass the reasonable classification test. Apart from this, there's another very interesting judgment to be looked at, which we all look at when we look at fundamental rights and violations, is the Shaira Bano versus Union of India case, where a legislation can be struck down if it is manifestly arbitrary. Now, what does that mean in legal terms? How is it examined? What does it look like? It's very keen to protect persons from religious persecution in undivided India. We know that Pakistan and Bangladesh were part of undivided India, but Afghanistan never was. So why has Afghanistan been then included in this category? What are the implications of this act for Muslims who have been living in India? There are concerns that the fundamentally statutory exclusion could, and this is very important to understand for rational people, by manipulation and interpretation, also impact those Indian Muslims who have never migrated, have always lived here for generations, but will subsequently be required to produce a slew of documents hitherto not available to over 40% of Indians, especially as and when the NPR NRC exercise is launched. What are the implications of the law for Muslims who've migrated to India? By implication or interpretation, Muslims who seek Indian citizenship by naturalization, that is an application, as I said earlier, made after 12 years of residency as migrants or refugees, will not be eligible for grant of citizenship by right. Earlier, it was by right, because after you live here for 12 years, you could be naturalized. Now, because of this amendment, it is the discretion of that application procedure. What will happen to people who cannot claim citizenship under this act? The implications, as usual, have not been enumerated in the law itself. But taking Assam as an example, and I'm saying this with some sense of responsibility, one can infer that such persons will find themselves being detained in detention camps, preparations for which have already begun in states like Maharashtra, Karnataka, and West Bengal. Our proposals for this amendment, a sudden move. The Modi government has, since it came to power, laid the groundwork for the CAA 2019 by amending the Passport Act and the Foreigners Order of 1948. So in 2015 and in 2016, these two amendments took place. What does this amendment mean for Muslims in Assam? Those Muslims who have been excluded from NRC and belong to the non-tribal areas of Assam and who are not able to prove their citizenship before the tribunals or the High Court or Supreme Court could be immediately sent to detention camps. Does this amendment mean that only migrants belonging to the Muslim community will be termed as illegal migrants? By implication, yes. Finally, what does the CAA 2019 do? This amendment to our citizenship law creates an other like no other law ever has. This is actually telling the Muslims in India that they will never be able to win the loyalty test. The very fact that there already is a loyalty test, only from them in a myriad ways, is a fact. But the fact that there now is such a law that says that they will never pass those tests is something that they will have to live with forever or till this amendment is repealed. CJP has been, apart from Assam, closely monitoring how the central government has been insidiously already operationalizing CAA 2019 even before the rules came into place. In November 2022, we reported on CJP, a colleague of mine reported, and I said this in Kolkata, that has the implementation of CAA 2019 already begun? And how did we discover this? We found that the Ministry for Home Affairs had already delegated 31 districts to grant citizenship under the CAA. In short, while it tells the Supreme Court that don't stay the law because we are not doing anything, we have not brought in the rules, it already operationalizes the Act through an executive order of the MHA reported in its own report of 2021-22. This is not a government that is really functioning by the book, by the law, and certainly not by the Constitution, which is why we need to be extremely vigilant, because again in March 2024, along with an organization in Kolkata, CJP also exposed that how the Union of India has possibly taken a giant step towards both the NPR and the NRC in 2015 by seeding Aadhaar database as the NPR database. And the final question which people are asking is, was it right, was it morally and legally right for the government to actually bring in the rules when the matter is still sub judice before the Supreme Court, and it had assured the Supreme Court the rules have not been operationalized? So many questions and very few answers. The CAA 2019, on its own, with or without the NRC NPR, promises to be hugely problematic and also unleash a sense of complete insecurity and discriminatory bias in the administration. It is likely to be a precursor for an All India NRC and NPR, in which case we are really in for a period of deep social torment.